rise.
Good afternoon, you may be seated. Okay, we're in court in a case of State of Ohio versus Marque Brown, 2014 CR 361. The state's represented by Assistant County Prosecutors Brett Hardup and Margaret Draper. The defendant is in court. He is in custody of the County Sheriff's Department. He is represented by Attorney Dean Topolov and Richard Donalfo. On February 5th of this year, the jury returned a verdict on this case. The defendant was found not guilty on counts 1 and 2. He was found guilty on counts 3, 4, and 5, and the state of Ohio had previously dismissed count 6. We are here for a sentencing hearing. First of all, looking at the counts and having heard the evidence, the court is of the opinion that count 5 should merge into count 3. Is that the state's understanding?
Yes, Your Honor.
Is that your understanding, Mr. Topolov?
Yes, it is, Your Honor.
Okay. Is there any reason why the sentence should not now be pronounced, or anything Mr. Brown or his lawyers would like to say in mitigation?
Yes, Your Honor. On behalf of Mr. Brown, and then Mr. Brown would also like to make a statement to the court, Your Honor. Your Honor, we were also asking for the court to consider merging the 2 involuntary manslaughter charges, counts 3 and 4. Although there were the 2 deaths here, the death of Taisha Ramirez and the death of the unborn child, both occurred based on the action and events of one occurrence, the alleged punching of her as the proximate cause of that injury and that death. We ask you to merge those 2 counts for sentencing. The court does have a lot of discretion here for this type of offense. We know Mr. Brown could be facing anywhere from 3 to 11 years. We ask you to take into consideration that he has never been convicted of a felony until this occurrence. He has never been to prison. He acknowledges, and I think everyone would acknowledge, this was a terrible tragedy. This is not what he wanted to happen, not what he expected through his actions. He loved Taisha Ramirez. He was so looking forward to the birth of his son. The times we've been talking to him, me and Mr. Donalfo in the jail, you can tell he's in a state of deep depression over everything that's happened because of the death of these loved ones. I know he will personally apologize to the family and apologizes for everything that happened here. He wishes he could take that back. We'd also ask you to consider that his age, he's very young. At the time this happened, he is a Lakeside High School graduate in Ashtabula. That's where he met Taisha. They were in high school together. He informs me he got good grades in school. He played football. He was looking at going to college. He's a family, and he is originally from Lorain, Ohio, but has been living here in Ashtabula County, Your Honor. He also informed me he attended the People's Baptist Church. He is a religious person, and I know has been praying about this case a lot. He's also was working, he told me, through summer jobs through Infinity Resources, and was trying to be productive. We would ask you to take all that into consideration in imposing sentence today, and take into consideration also what Mr. Brown will say to the court. Thank you.
Mr. Brown, you are entitled to make a statement, sir.
I'd like to say sorry to the family. Sorry. You know, my prayers go out to them, and hopefully they pray for me as well, because I don't deserve this. And have mercy on my soul. And, you know, may God Almighty walk with me through this pain I'm going to go through, all my life. That's really all I'm going to say right now.
Okay. Anything else, Mr. Topolov?
No, Your Honor.
Mr. Hardup, on behalf of the state, does the family wish to make a statement?
No, Your Honor.
Okay. On behalf of the state, then, Mr. Hardup.
Thank you, Your Honor.
Well, first, the state would like to address the request by council for the merging of counts 2 and 3.
3 and 4.
Or 3 and
Sorry.
4, my apologies. These are separate victims. Your Honor, the state argues by law these do not merge. Would ask the court not to merge counts 3 and 4.
I'm not going to merge counts 3 and 4 because my long understanding of the law is you don't get to take 2 lives and only pay for 1.
Thank you, Your Honor. Marque Brown, according to Asheville Police Department reports, when he was a juvenile in 2008, got into a fight at Lakeside Junior High School. Assistant principal tried to separate him, and the assistant principal got punched. He was suspended. In 2012, when he was 18 years old, he had a disturbance with his mother, Christina Brown, and he indicated he didn't feel loved by his family, so he kicked in and damaged a door for the house that was being rented. June 2012, he assaulted Kenny Cedino, who is the brother of Taisha Ramirez. That assault occurred when it was learned, when the defendant was 19, he was having sex with Taisha, who was 15. He admitted there was an argument, the defendant admitted there was an argument, and that he hit Kenny. And throughout his history with the Asheville Police Department, he gets angry, he starts hitting things. The most recent up to the events that unfortunately happened on May 25th, 2014, was resulted in an arrest for an aggravated robbery, in which Ronaldo Gomez, who says a person known to him as Marque, pistol whipped him when Mr. Gomez didn't give him his tax return money. The Asheville Police Department reports indicates that Mr. Gomez did positively identify Marque, the person that he had known, was in fact the defendant. That matter was charged in the Asheville Municipal Court, however, was dismissed when the complaining witness did appear for the preliminary hearing, but left prior to it starting. That incident occurred on February 20th, 2014. May 25th, 2014. He gets angry again, and the court heard all the testimony as to what had happened and the injuries that were sustained by Taisha Ramirez, both on her inside her mouth, on the outside of her head, and the injury and damage that it caused. At no point in time throughout this case has Mr. Brown ever shown any type of sincere remorse for what has happened. The only time that it so far it has been brought to this court's attention and the state of Ohio is just now when he apologized to the family, but immediately followed with saying he doesn't deserve this. The state disagrees with that statement. Taisha Ramirez is 17 years, 9 months, 3 days old. She was expecting that baby, who was in gestation for 8 months. They didn't deserve this. And for those reasons, Your Honor, for the facts that were presented at trial, the state is asking for the 11 years on count 3 and the 11 years on count 4. I believe credit for time served at this time is 641 days, and the state is asking for those counts in the sentence recommendation to be consecutive. Thank you.
Thank you. The court has looked at the defendant's record. The court does look at and has to consider the purposes and principles of the sentencing statutes. The overriding purpose is to punish offenders and protect the public from future crimes. Based upon what the court's been told, the recidivism factors, it appears that recidivism is likely. The court court's looked at the seriousness factors. The defendant took 2 lives, 2 innocent lives. It doesn't get any worse than that. It doesn't get more serious than that. The court does find that consecutive sentences would be necessary to protect the public from future crimes and to punish the offender, and that considering 2 innocent lives were stolen from this family, that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and of the danger the defendant poses to the public. Any term of community service would demean the seriousness of the offense and would not adequately protect the public. After having heard this case, I did not order a pre-sentence investigation because it was clear, based upon the brutal beating she took, that community control would not be acceptable. So, on count 3, it will be the sentence of this court that the defendant be confined in a state prison for a term of 11 years. There will be no fine. He will have court cost. On count 4, there will be a term of 11 years, no fine, and court cost. Those 2 sentences shall be ordered to be served consecutively or one after the other. But I don't believe this is a mandatory sentence.
This is not a mandatory sentence, Your Honor, so I believe, without having looked at that particular issue for the court at this point in time, but my past experience review of those statutes, that you would be entitled to the 8%.
Okay,
So the state would ask for the court to give that notification, and if it turns out wrong, it would be harmless error.
Okay, I will notify you, Mr. Brown, that you may be eligible to earn days of credit to reduce the prison sentence for each completed month of productive participation in educational or employment programs as specified in Ohio Revised Code Section 2967.193. The credits are not awarded automatically and must be earned. The sentence may be reduced by up to 8% for the credits earned. Now I'm required to go over this notification with you. After you are released from prison, you will have a period of post-release control for 5 years following your release from prison. If you violate a post-release control sanction that's imposed upon you, any one or more of the following may result. The parole board may impose a more restrictive post-release control sanction upon you. The parole board may increase the duration of the post-release control subject to a specified maximum. The more restrictive sanction that the parole board may impose may consist of a prison term, provided that the prison term cannot exceed 9 months, and the maximum cumulative prison term so imposed for all violations during the period of post-release control cannot exceed 1/2 of the stated prison term originally imposed upon you. If the violation of the sanction is a felony, you may be prosecuted for the felony, and in addition to any sentence it imposes on you for the new felony, the court may impose a prison term subject to a specified maximum for the violation. And then you will sign this. You're simply acknowledging that I notified you that when you get out of prison, you're going to be on post-release control. That's required. I don't have any discretion in that, and there's nothing your lawyers can do about that. And you don't have the means to pay a fine, you will have to pay court costs, and judgment is rendered against you for the court costs. There is no community service, no driver's license suspension, there is no restitution. Any rights you had to bond was canceled on February 5th when the jury returned the verdict of guilty. I am advising you that you have a right to appeal the court's conviction and sentence. You have 30 days from the date that we put the sentencing entry on to file your appeal with the 11th District Court of Appeals. You have a right to a free court-appointed lawyer to represent you in the Court of Appeals, and you have a right to a free transcript of all of the court proceedings that could be prepared for you at no cost. Do you understand those rights, Mr. Brown?
Yes, sir.
Okay. Initially, I'm going to appoint these 2 attorneys to represent you in the Court of Appeals. It is not uncommon for those lawyers to withdraw once the case gets in the Court of Appeals, and for the Court of Appeals to appoint different counsel to represent you. That's a standard proceeding. Do you understand that, sir?
Yes, Your Honor.
Anything further on this, Mr. Olive, on behalf of the defendant?
Your Honor, if I may,
Yes.
jail credit in this case.
His jail credit in this case will be 641 days as of today. I believe we did discuss that briefly in chambers,
We
but I
did.
may not have said it on the record. Anything further, Mr. Denolfi?
No, sir.
Mr. Tapala?
There, Your Honor.
On behalf of the state, anything further?
No, Your Honor, thank you.
Okay, Lieutenant, would you please remove Mr. Brown from this courtroom? Everyone else, stay right where you're at.
Yeah.